Dixon versus International Harvester deals with another limitation on the doctrine of subsequent remedial repairs. And remember, courts don't like this doctrine. And they don't like it for the same reason that often courts don't like the exclusionary rule. We're losing reliable evidence. We're losing evidence that goes to the question of whether one person was at fault. What is it courts do? Courts try to determine truth. They try to identify, in the case of a tort, what caused this accident. We'll figure out damages later. We'll figure out if there was contributory negligence. We'll figure out how much someone should pay. But at its core, we want to know why something happened. When we ask the question about whether we should exclude evidence of subsequent remedial repairs, what we're saying is, should we deprive courts of a way to actually figure out who was responsible for this accident to encourage some good societal policy? Now, it's not entirely clear that this exclusion of subsequent remedial repair evidence is actually achieving the goal. I mean, think about this. If you've got an ice cream parlor and there's a crack in the sidewalk outside of it, you may lose this one lawsuit because we learn in the course of the lawsuit that you repaired the sidewalk. But if you don't repair that sidewalk, what's going to happen? You're going to be sued again and again and again for all the people who trip and break their back. So there may still be incentives that override the deterrent effect of the fear of having this evidence used against you in the liability determination. So we're not even really sure that the doctrine of subsequent remedial repairs is necessary to make sure that homeowners or ice cream parlor owners or big corporations actually fix their equipment or their sidewalks or their factories, or in the case of the shopping mall in McIntyre, actually hire security guards. We're not really sure we need this doctrine, and this doctrine comes at a cost. So what you find is, in the case of the Honolulu example, the Honolulu litigation, that the courts found a way there to say, look, this repair was already planned. That's not going to deter the repair if it's already planned. So what if a jury hears it's going to happen? They're not going to say, oh, stop the repair because we're afraid of it being used against us in court. So the courts are looking for any way to cabin the concern that animates the rule. That if we can find a way to say that this repair would have gone on anyhow, that this rule is not really a deterrent to the repair in this particular instance, we'll find an exception for it. And so that's the case in the Dixon versus International Harvester case. In Dixon, the plaintiff victim, and in this case, the plaintiff is represented by his widowed spouse, because he dies as a result of this. He's out with his tractor, working for International Paper, unrelated to International Harvester. Those two companies have no connection whatsoever. International Paper bought the tractor that was built by International Harvester, and it didn't have a plate under it that keeps brush from popping up and striking the driver, as it did in this case. After the employee of International Paper was driving the International Harvester tractor, and a piece of tree brush, after one of the hurricanes in the area, came up and speared the victim in this case, the plaintiff. After that happened, International Paper decided to fix the tractor, to put something on the tractor to keep that from happening again. In the lawsuit against International Harvester, the folks who made the tractor, the plaintiff wants to introduce evidence that International Paper chose to fix the tractor, to modify the tractor that was made by International Harvester. Can you do that? Can you introduce that evidence? And the court says yes. Yes, because unless it is the actual manufacturer making the change, we're not concerned that this will deter anything done by the manufacturer. That the idea is that International Paper is not going to be thinking one way or the other about a suit against International Harvester. Who cares what happens in that lawsuit? And so the court held that in this case, the deterrent that we're afraid of this type of evidence deterring somebody from acting. But who acted in this case? It was International Paper, the folks who owned the individual tractor, not the folks who made the tractor. Those were the people who made the modification. And so we're not afraid of deterring International Paper from modifying an individual tractor that they own, because they're not the folks being sued for this. So if you're not the defendant and you modify a piece of equipment, then that will still come in, so long as you're not the defendant. Courts are looking for any way to cabin the fear that we have, looking for exceptions under the particular case that suggest that the policy justification does not apply in this case. If it's already planned, then we're not worried that they'll stop the repair. If in this case, the people who did the repair aren't being sued, we aren't worried that they would have not made that repair, because there's no fear that repair will come in the lawsuit against them, because there's no lawsuit against them. Key upshot of this is that the doctrine of subsequent remedial repairs operates only when it is the person being sued who made the repair.